In the case of Gray and Pearson, Lord Wensleydale said, "In construing statutes, the grammatical and ordinary sense of the words is to be adhered to, unless that would lead to some absurdity, or some repugnance, or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of the words may be modified, so as to avoid the absurdity and inconsistency, but no farther." He was describing, of course, the golden rule of statutory interpretation. A case involving the golden rule is Maddox and Storer. There are generally taken to be two approaches to the golden rule: the narrow approach and the broad approach. The narrow approach is used where a word, or words, in a statute can have more than one meaning. In these cases, the judge is able to select the appropriate meaning of the word in the context in which it is being applied. In the case of Maddox and Storer, it was the narrow approach that was used by the court. The facts on which this case was decided arose on Shore Lane, an isolated street in Markfield, Leicestershire. On March 12, 1961, on Shore Lane, Mrs. Lydia Iris Storer was arrested for breaking the speed limit whilst driving a minibus. She was prosecuted and found guilty. The magistrates found that the defendant, Mrs. Storer, had driven the minibus, which was able to carry over 7 people at 50 miles an hour, on Shore Lane, which broke Section 24, Schedule 1 of the 1960 Road Traffic Act. This act laid down limits of speed for vehicles of certain classes or descriptions, stipulating the maximum speed in miles per hour of vehicles in certain categories. The vehicle Mrs. Storer was driving came under Section 24.1 as a vehicle having an unladen weight exceeding 3 tons or which had been adapted to carry more than 7 passengers exclusive of the driver. It was the meaning of the word adapted that the outcome of this case would turn on. The police appeared to have Mrs. Storer banged to rights, as we say. The minibus was capable of carrying 11 passengers, more than 7 laid down in the statute. Mrs. Storer was caught driving the bus at 50 miles an hour. However, the question was whether or not the minibus could be said to be adapted for carrying more than 7 passengers. In the English language, the word adapted is similar to modified or refitted. The minibus had not been adapted, modified, refitted, or changed in any way. Its original design and construction provided for 11 people to be carried. Would this technical point be enough to rescue Mrs. Storer from prosecution? At first instance, the magistrates found Mrs. Storer not guilty. Their opinion was that the vehicle had not been altered in any way. Mrs. Storer was charged with driving a vehicle which had been adapted to carry more than 7 people. The prosecution appealed the matter, however, by way of case stated to the High Court. The High Court allowed the prosecution's appeal. Lord Chief Justice Parker gave the reasoning as such. The principles on which they, the magistrates, approach the matter are in general correct, but in my judgment, even where the same word does occur in the same section or the same schedule, the context must govern the true meaning. Where adapted is used disjunctively to constructed, it can only have one meaning, namely, if it was not originally constructed for the particular purpose, then it has been altered and made fit for that purpose. In other words, it can only mean a physical alteration making it fit. It could not possibly be given the meaning that it is merely apt, fit, and suitable, because if so, it would add nothing to the original word constructed. When, however, one gets the word adapted used on its own, then in my judgment, one must look to the context, and if one gave it a meaning in paragraph 1 subsection 1 of the first schedule of being altered so as to make fit, it seems to me to make nonsense of the provision. A minibus, as originally constructed, can go at any speed, whereas if there had been some slight alteration making it fit to carry more than 7 passengers, it is confined to 30 miles an hour. One can get illustration after illustration on looking at the Act itself, where adapted, when used disjunctively with constructed, must mean a physical alteration, and, as it seems to me, other cases where the word adapted alone is used, and where it must be given the adjectival meaning of being fit and apt for the purpose. Accordingly, the case must be remitted to the justices with a direction that they came to an incorrect decision in point of law, in holding that adapted must be read as altered so as to be apt. In plain English, what had happened here was that the judge decided that the word adapted, given the fact that it was used alone in the section of the Act, must surely be taken to mean constructed as well. To have things any other way would have been rather silly. It would mean that only people driving vehicles that had been changed so as to accommodate more people would be liable to prosecution for breaking the speed limit. Given that the word adapted can have more than one meaning, the judge took the narrow approach and chose the meaning which made the most sense within this context. And, for our purposes, nicely illustrating this particular method of statutory interpretation. And now it's time for Rory Mayo's top tips.
Rory Mayo's top tips.
The narrow approach contrasts with the broad approach. Unlike the narrow approach, where a word in an act is capable of having more than one meaning, the broad approach is used where the word only has one literal meaning. For an example of a case where the broad approach is used, see the case of Adler and George from 1964.